Welcome to all. Today, as a part of the course on insolvency and bankruptcy law in India. So, in the next two lessons, we are going to discuss insolvency professional agents, and next class we are going to discuss insolvency professionals. Then we are going to discuss information utilities. Okay. So, before that, in the previous class, we have discussed about section 12A, where we have discussed the position prior to section 12A, withdrawal application, then withdrawal application under section 12A, after section 12A, what is the position right now, and the role of NCLT in accepting the withdrawal. Then we have discussed about applicability of section 29A in case of withdrawal, whether ineligibility prescribed under section 29A, is it applicable in case of withdrawal or not, we have discussed. Then whether withdrawal is allowed during the liquidation. So if you read barely the legislation, withdrawal cannot be allowed during the liquidation, but in the interest of the justice, in few judgments, they have allowed withdrawal during the liquidation also. Okay, the position is yet to be settled by the Supreme Court. Whether the right of objection is available to the other creditors, no, the right of objection is not available to other creditors. Then whether the resolution applicant can invoke section 12A. No, resolution applicant cannot invoke section 12A. So these are all the various things that we have discussed in the previous class while we are discussing the section 12A. So today we will start the concept of IPS. Okay, so insolvency professional agencies. So if you observe the legislations, so who is going to implement? So prima facie at the top level you are having IBBI, there is a board which is going to monitor IPS and professional agencies. There is another judicial body is there, NCLT, NCLT. Judicial structure is NCLT, NCLAT, then Supreme Court. Okay, so that is a structure. So let us discuss about insolvency professional agencies. What is the legal framework? The Insolvency and Bankruptcy Code IBC 2016 provides for creation of following institutional framework. One is IBBA, who is a regulator. Okay, insolvency professional agencies, IPS, first level regulator of insolvency professionals. Why? Because all insolvency professionals will be registered with the insolvency professional agencies. Then insolvency professional agencies will share the data with the IBBA. And these insolvency professionals, they are expected to register with the IPS as well as get the registration from the IBBA also. Okay. Then insolvency professionals. So these are all the individuals who are authorized to conduct the insolvency resolution process. They have created a separate profession to take care of the resolution process under the legislation. Then adjudicating authorities are also there. So like NCLT, then for the corporates, then debt recovery tribunals for the individuals. Okay, so this is a legal framework for the insolvency professionals and insolvency professional agents. So today we are going to discuss insolvency professional agents. In the next class, we are going to discuss insolvency professionals. Let us discuss about insolvency professional agents. So the insolvency professional agency is an organization registered with IBBA that enrolls and regulates insolvency professionals. So if you observe what insolvency professional agency will do. The Insolvency Professional Agency is an organization which is registered with IBBA. We are going to discuss how it is going to be registered, and that regulates and enrolls. So first of all, they are going to enroll, then subsequently they are going to regulate the insolvency professionals, okay, who are considered to be backbone of this resolution process. Okay, so and oversee their conduct and performance. Then IPS are governed by IBC code, and we are having regulations also, IBBA Insolvency Professional Agencies regulations. So these regulations define the eligibility, registration, duties, governance, disciplinary processes relating to IPS. Okay, so we are going to discuss all these things now. Now let us discuss the eligibility criteria. So if I want to register as an IPA, can I register? Or else who is eligible to register as an IPA? So as per IBBI, IPA regulations 2016, so who is eligible to register as IPA? So the sole object is to carry on the functions of an insolvency professional agency under the code. So if I want to register as an IPA, my sole objective of the creation must to be to carry on the function of insolvency professional agency under the code. So I'm not supposed to do any other activity. So my main object of creation of entity must always be to carry on the objects under IBC. Then it has a bylaws. So you are expected to have the bylaws and governance structure in accordance with the Insolvency and Bankruptcy Board of India, model bylaws and governing board of Insolvency Professional Agencies Regulation 2016. We are having separate regulations are there for the bylaws. So you are expected to have the bylaws and as well as governance structure in accordance with the IBC. Then it has a minimum net worth of 10 crore rupees. Okay. Then minimum paid up share capital 5 crore rupees. So net worth 10 crore rupees, paid up share capital 5 crore rupees. Okay. Then what is the other condition? It is not under the control of any person resident outside India. So the IPA should not be under the control of any person who is resident outside India. So we know the meaning of resident in India, resident outside India. Okay, if any person is staying in India for more than a minimum of 180 days, then he is considered to be resident in India. Okay, so already we have discussed the definition of resident in India and resident outside India. Okay, so the control of the IPA shall not be in the hands of person resident outside India. Okay, and not more than 49% of its share capital is held directly or indirectly by the person resident outside India. So the share capital minimum more than 51% must be in the hands of resident in India. Okay, then it is not a subsidiary of body corporate through more than one layer. So that means it should not be a subsidiary. That is not possible. Okay, so maximum one body corporate is there. To such body corporate directly it is a subsidiary. Okay, so it cannot be more than in one layer. Okay, so it cannot have holding company and holding company to such other company. So that is not possible. Okay, then the applicant, its promoters, its directors and its shareholders are fit and proper person. Okay, so what they are going to do? What is the functions and duties? What are the functions and duties of IPA? So as per the regulations, IPAs are having following responsibilities. Okay, so enrollment and regulation of IPs, insolvency professional. So one of the major function of IPAs is enrolling and regulation of IPAs. So they are going to admit the members who are qualified to become the insolvency professionals. In the next class, we are going to discuss who can become the insolvency professional. So we are going to discuss the eligibility criteria, etc. in the next class. Okay, so this IPAs, insolvency professional agencies, they are going to admit the members who are qualified to become the IPs. Okay, then ensure that members meet the eligibility criteria and competency criteria. Okay, how you are going to build the competency? So you are supposed to regularly attend the conferences, seminars. You are expected to complete the credit hours compulsorily. Anyway, we are going to discuss all these things in the subsequent lessons. Okay, then code of conduct. So IPA is going to prescribe the code of conduct and ethical standards for the insolvency professionals. As already I told you that IPA is the authority, first level authority, who is going to regulate the insolvency professionals. Okay, so they are going to prescribe the code of conduct and ethical standards for the IPs and ensure compliance with the model code of conduct. Okay, so IBBA, they have provided the model code of conduct and that is same as it is. Okay, so in total that is adopted by the IPAs also. So ensure that its members are following the code of conduct. Then training and development. So they are going to organize continuing professional development. It is also called a CPE program. Okay, so continuing professional education, and help the members to stay updated with the regulatory changes. So every year when you are a member of IP, you are expected to complete minimum credit hours are required. Okay, so CPE hours are required. So you are expected to complete the CPE hours. Okay, then grievance redressal and disciplinary mechanism. So IPA is going to set up the system for redressal of complaints against the IP. So if any third party or if any customer is having any grievances against the insolvency professionals, then you can make a complaint before the IPAs. Okay, then they are going to conduct the investigation and they are going to take the disciplinary actions in coordination with the IBBA. Okay, so please remember, whenever they are taking any disciplinary actions, so it is always in coordination with the IBBA, because when you are taking disciplinary action, both IBBA and IPA both will come into the picture. Then monitoring and compliances. So monitor the professional performance of IPs, how they are performing, and they are supposed to submit reports to the IBBA on IP activities. Okay, so if any misconduct is there, if any internal complaints are there, then in such cases these things must be intimated to the IBBA from time to time. Okay, then how it is going to be governed? What is the governing structure of IPA? Let us look at the regulation level. Okay, at the regulation level, Regulation 5 of IBBA, Model Bylaws and Governing Board of Insolvency Professional Agencies Regulations, okay, 2016, which provides for the governing structure. Okay, so what is the composition of governing board IPA? So the governing board shall consist of managing director, independent director, shareholder director. So three people must be there. Okay, so managing director, three categories. It's not three people, three categories. Okay, so one managing director and independent directors and shareholder directors. Then provided that the governing body shall have minimum 7 directors. Okay, so these three categories must be there. Minimum of 7 directors must be there in the governing board. Then the managing director shall not be considered either as an independent director or shareholder director. So while calculating these three categories, that is managing director, independent director, shareholder director, this managing director cannot be included in the independent director and shareholders director. This is separate. Managing director is separate. Apart from him, you are expected to have shareholders director and other directors. Okay. Then any employee of insolvency professional agency may be appointed as a director. Okay, in addition to the managing director. So please remember, employee of the insolvency professional agency can also be appointed, but he cannot be a managing director. Okay, managing director is separate. So, but such director shall be deemed to be shareholder director. Then more than half of the directors shall be resident in India. Okay, so at the time of their appointment, they shall be resident in India and at all times during the tenure as a director. So they are expected to be resident in India. Okay, so more than half of the directors. Then who are all the registered IPAs in India? So IBBA, as of now, they have recognized only 3 IPAs, insolvency professional agencies. Okay, so one professional agency is promoted by ICAI, Institute of Chartered Accountants of India. That is Indian Institute of Insolvency Professionals of ICAI. It is also called as ICAI IAP. Then promoted by Institute of Company Secretaries of India, ICSA Institute of Insolvency Professional, ICSA IAP. Then Insolvency Professional Agency of Institute of Cost Accountants of India. Okay, so it is promoted by ICMAI. Okay, so these three IPAs are there right now. Okay, then Role of Insolvency and Bankruptcy Board of India. So what they are going to do? So the IBBA is the apex regulatory authority. Okay, so above IPs, insolvency professionals, and above IPAs, IBBA will be there. Okay, so the key role includes registering and regulating IPAs and IPs. So both are regulated by IBBA, Insolvency Bankruptcy Board of India. Okay, so they are going to register IPAs and IPs. Then setting eligibility criteria, examination process. So the examinations, IP examinations are conducted by IBBA. Okay, then training requirements, everything is prescribed by the IBBA. Okay, then issuing rules and regulations and guidelines for IPS. Okay, how they are supposed to regulate the IPs. Okay, their internal control mechanism, everything is prescribed by the IBBA. Okay, then are they complying with the rules and regulations? So IBBA is going to monitor regularly. Okay, and taking enforcement actions. Then supervising the conduct of IPs through IPS. So IBBA can directly interact with IPs, but generally they'll interact through IPS. Okay, so through insolvency professional agencies. Okay, so they are going to supervise the conduct of insolvency professionals. Okay, then disciplinary proceedings. Okay, how IPA can take the disciplinary proceedings. So when IPA receives a complaint or else they have identified a misconduct of the member of IP, because we are having 3 agencies are there, though these 3 agencies will have the members. Okay, so if they found misconduct by any of their member, then they can do the investigation internally. Okay, so internal investigation will be conducted. Then disciplinary committee will be formed. Okay, they are going to examine the case, they are going to receive the evidences from both the parties. Okay, accordingly they are going to take the decision. Okay, so what actions they can take? Okay, they can issue warning or reprimand, or they can go for suspension. Sometimes they can expel the member. It is exceptional cases. Sometimes they can go for expulsion of the member also. Okay, so they can report the matter to IBBA for further action. Okay, so there are instances where they have given the order to the member to undergo training once again. Okay, so mandatory hours training will be there before admission to the insolvency professional. So there are instances where they have given order against the member to undergo the training once again. Okay, depending on circumstances. Okay, so they can give the orders accordingly. Then importance of IPS in the insolvency ecosystem. What is the importance? Okay, so they professionalize and standardize the insolvency practice because they should be a mechanism. Okay, so internal control mechanism must be there. So these IPs, majority of the cases, they belong to the professional, either advocate, company secretaries, or chartered accountants, cost accountants. Okay, so majority of the cases, they are all professionals. Okay, they should be a mechanism how they are going to be regulated. So this IPAs will create the ecosystem where you are going to regulate them. Okay, so and they are going to standardize the insolvency practice, then serve as a self-regulatory organization under the IBBA oversight. Okay, so it is going to regulate themselves. Okay, it is going to regulate the IPs also. Then facilitate capacity building of professionals. As already I told you, there is a concept of CPE, continuous training programs will be there. So capacity building will be done to the professionals. Then it acts as a bridge between the regulator and insolvency professional. As already told you, insolvency professional, then above them IPA, then IBBA. So this IPA is going to act as a bridge between IBBA and the professionals. Okay. Then who can be an IPA? So if you observe section 199 of IBC, which provides that, save as otherwise provided in this code, no person shall carry on its business as IPA under this code and enroll any insolvency professionals, IPs, as its members, except in accordance with the certificate of registration. So you are expected to get the certificate of registration if you want to act as an IPA. So if you want to enroll any IPs under you, or if you want to act as an IPA, you are expected to get the certificate of registration. Okay. So what are all the principles governing the registration of insolvency professional agency? So these are all the various principles to be there. Okay, these are all governing principles. So prima facie, it is to promote the professional development of an regulation of insolvency professional. Okay, so basically this IPAs must be created to promote the professional development. Okay, to promote the services of competent insolvency professionals to cater to the needs of debtor, creditors, and such other persons as may be specified. Okay, so they are there to promote the services of competent insolvency professionals. Okay, so they are supposed to groom the insolvency professionals. Then to promote good professional and ethical conduct amongst the insolvency professional, to protect the interest of debtors, creditors, and such other persons. So IPAs, they are expected to protect the interest of debtors, creditors, because they are serving the community, stakeholder community at large. Then to promote the growth of insolvency professional agencies for the effective resolution plan. Okay, then how you are going to do the registration? So application for registration shall be made to the board. So board is going to give the registration certificate. Okay, so once if you make an application, there are prescribed formats are there. So once if you make an application to the board, then board, if it satisfies that conditions are satisfied, I mean we are having the conditions, no, net worth, turnover, so minimum paid share capital. So if you are satisfying these conditions, then they can issue the certificate of registration. Okay, or they can go for rejection also. Okay, they may accept or they may reject. So if they are rejecting, then they shall be giving an opportunity of being heard. Compulsorily, an opportunity of being heard must be given before rejecting. Okay. Then the certificate of registration must be in the prescribed format. There are prescribed formats are there. You are expected to give the certificate of registration in the prescribed format also only. Okay. Then renewal certificate will be there. So the certificate will be valid for a particular period of time only. Once the period is completed, again you have to make an application. It's a regular process. Okay, renewal will be done. Then if any IPA fails to follow the terms and conditions, because as already I told you, IBBA is going to prescribe the internal rules and regulations. So if any IPA fails to follow the rules and regulations, then they can go for suspension of cancellation of registration. Okay, so if any IPA, if they are not satisfied, then where they can go? Section 202 of IBC provides that any insolvency professional agency which is agreed by the order of the board, okay, so made under section 201, may prefer an appeal to the NCLAT. So please remember, this is an appeal before the NCLAT. It's not an appeal before the NCLT. So you are supposed to make an appeal before the NCLAT in the specified manner as might be prescribed. Okay. Then how is the governing board? Okay. So what is the constitution? So section 203 is a basic section. Okay. So which is providing for governing board of insolvency professional agency. So according to section 203, the board may, for the purpose of ensuring that every insolvency resolution professional takes into account the objective sought to be achieved under this code, they may make the specific regulations relating to setting up of governing board, how the governing board must be, what should be the composition. So they can make the rules and regulations. Okay. So accordingly, we have discussed previously. Okay. Then the minimum number of independent directors to be there. Okay. Then the number of insolvency professionals being its members who shall be on governing board. So how many insolvency professionals must be there in the board of insolvency professional agencies. Okay, so even insolvency professionals will be members in the governing board. So all these things are prescribed. Okay, so IBBA is going to prescribe the rules and regulations. Okay, then let us discuss about functions of insolvency professional agents. Okay, what they are going to do. So if you observe section 204, which clearly provides that, okay, so they are having power or they are having an obligation to grant membership to persons who fulfill all the requirements set out in the bylaws on payment of membership fee. Okay, so in the next lesson we are going to discuss who can be insolvency professional, eligibility criteria, etc., etc. So once if he satisfies the eligibility criteria, then it is the responsibility of insolvency professional agency to grant the membership. Okay, then they are going to lay down the standards. Okay, standards of professional conduct, then how to conduct the CRP process, etc., etc. Internal circulars will be issued, guide note will be given. Okay, then monitor the performance of its members. They are going to monitor. Then safeguard the rights and privileges of interest of insolvency professional who are all members. Then suspend or cancel the membership of insolvency professionals. Okay, so in the bylaws, if there is any fraud is involved, okay, if the members involved in the fraudulent activities, there are grounds are there where in such cases IPA is having power to suspend the membership. Okay, then redress the grievances of consumers against the insolvency professionals. Okay, so the consumers can be maybe creditors, maybe debtors. Okay, so anyone can be the consumer in this case. Okay, then publish information about its functions, list of members, performance of its members, such other material or information as may be prescribed by the rules and regulations. Okay, so in the rules and regulations, IBBA is going to prescribe what to be published. So they are going to publish, IPA is going to publish all such data. Okay. Then insolvency professional agency, they are expected to make the bylaws. So if you observe section 205, which clearly provides that subject to provisions of this code and any rules or regulations made thereunder. So after obtaining approval from the board. So every insolvency professional agency, they are expected to make the bylaws specified by the board under section 196. Okay, so they are expected to make the bylaws. So this is how insolvency professional agencies are going to work. Okay, so in this lesson we have discussed the legal framework relating to IPA. Okay, so various sections and the regulations. Then eligibility criteria, who can be registered as IPA. We have discussed the turnover, paid up share capital requirement, and there should not be more than one layer. So like this we have discussed the eligibility criteria. Okay, then subsequently we have discussed functions and duties of IPA. Then we have discussed the governing structure. So shareholders, directors, independent directors, managing director. So there is a structure is there. So governing structure we have discussed. Okay, then we have discussed about registration of IPA, how to make an application for registration. Then we have discussed about disciplinary proceedings by the IPA, insolvency professional agencies. Thank you.